A man, Mr. A, has been suffering from renal failure for a long time. Out of deep concern for her father's condition, his daughter decided to donate one of her kidneys to him. She visited the hospital to undergo a transplant, compatibility test and genetic testing to confirm whether she could be a donor. During the genetic testing, Dr. B discovered that Mr. A and his daughter were not biologically related. Should Dr. B inform the father and daughter that they are not biologically related?
When a man and a woman become a couple, pregnancy and childbirth may follow. Identifying the biological mother of a child is usually straightforward, since pregnancy brings visible physical changes, and childbirth often involves hospital admission. However, identifying the biological father is not always as simple. Some couples fail to conceive even after multiple sexual encounters, while pregnancy can also result from a single sexual encounter. In cases of extramarital affairs or other circumstances, it can be very difficult to determine who the biological father is. For this reason, many cultures around the world, both Eastern and Western, have historically placed strong emphasis on female chastity. However, with the development of modern genetic testing technology, it has become relatively easy to determine a child's biological father. As a result, new ethical and legal issues have emerged that did not exist before. A man who raises another man's biological child without knowing it is sometimes called a cuckoo father. Previous studies have shown that in Western countries, about 1.9% of fathers are in this situation. In East Asian countries, including Korea, where Confucian values remain influential, this number is believed to be lower. This brings us back to the medical context. If a physician, through genetic or other medical tests, happens to learn that a child is not biologically related to their legal father, should the physician disclose this information? If the doctor withholds the information, it could be seen as concealing the truth. On the other hand, revealing it could severely damage the family relationship between parent and child. A real case like this occurred in Canada. After much internal discussion, the medical team decided to disclose the truth to the family. The family experienced shock and pain, but eventually came to terms with the reality. Later, the daughter expressed that she was grateful to have learned the truth from the medical team, rather than discovering it later under different circumstances. However, following such incidents, hospitals in the United States ask patients and families to sign a consent form before conducting organ transplant compatibility testing. This form states that the hospital will not disclose information if the test reveals that the parent and child are not biologically related. What about Korea? Under the current Korean Medical Service Act, physicians are prohibited from disclosing or publishing any information they learn in the course of their professional duties about someone other than the patient. Other people here refers to anyone who is not the patient. This means that without the patient's consent, a physician cannot share medical information even with the patient's family. Therefore, if a doctor learns by chance that the child and legal father are not biologically related, and neither the patient nor the child has directly asked about this, legal experts say the physician has no obligation to disclose the information. Another related question arises: if the biological father is different from the legal father, does the legal parent-child relationship still hold? Let's consider a similar case. Mr. A married Ms. B. 2 years after their marriage, they still had no children. Medical testing revealed that Mr. A was infertile due to azoospermia. After discussing the matter, they decided to conceive through in vitro fertilization using donor sperm, and child C was born. Mr. A and Ms. B raised C together. Later, however, Ms. B had an extramarital affair, resulting in the birth of child D. Unaware of this, Mr. A believed D was his biological child and registered the birth accordingly. When D was in the 5th grade, a medical test unexpectedly revealed that D was not biologically related to Mr. A. Despite this, he continued to raise D for more than 5 years. Eventually, Mr. A fell out of love with Ms. B and divorced her. After the divorce, is Mr. A still legally responsible for supporting both children, C and D? In Korea, a child conceived during marriage is presumed to be the child of the husband. In addition, any child born 200 days after the marriage is presumed to have been conceived during the marriage. days after the marriage is presumed to have been conceived during the marriage. This means that regardless of biological parentage, the child is legally considered to belong to the married couple. This legal principle is called presumption of paternity. The main purpose of this rule is to maintain family stability, secure the child's legal status quickly, and prevent any legal uncertainty regarding parentage. If a man discovers that a child is not biologically his, he may file a lawsuit to challenge paternity, but only within 2 years of learning the truth. This time limit exists to protect the legal stability and welfare of children. Furthermore, Korean courts have ruled that, if a child is conceived through in vitro fertilization with the consent of the husband, the child is legally and socially recognized as the couple's child. The husband cannot later reverse his decision and claim the child is not his. Please leave your thoughts or opinions in the comments.